Hey, y'all, and welcome to tonight's live stream. The Murdaugh hearing this week, it made completely clear that the Murdaugh case has split the bar in South Carolina. The Murdaugh lawyers don't agree with the state on pretty much anything. We can tell that because it was a very tense, very exciting hearing. Much different from your average hearing. A lot of fireworks, a lot of argumentation about everything that was happening. So it was a dramatic triple hearing too. So we're going to talk about everything that happened in the hearing. I'm going to show you the key parts out of the hearing so you can see it for yourself and see what I'm talking about and why it was so incredibly dramatic, and showed that the state and the Murdaugh team, there's a serious split in the bar in South Carolina. They really have split over this case. It's been something that has changed the way lawyers got along in South Carolina, I would say. So this hearing, yesterday's hearing, had all three of the biggest players in the Murdaugh drama. All three of them appeared for a hearing yesterday. We had Alex Murdaugh, of course. He's the one accused of murdering his wife and son. He was convicted of that, in fact, in South Carolina, convicted of murdering his wife and son, but he still faces over 100 financial crimes. Then Russell Laffitte appeared. He is the banker who allegedly was supposed to be safeguarding the personal representative for the client money that Alex Murdaugh got in on several cases. And instead, the state says, we'll go into more of that later, but the state says he handed the money over to Murdaugh, and he's been already convicted in federal court. And now what's happening next is the state court. This was a state court hearing. Cory Fleming was the third person. He was an attorney, a close friend of Alex Murdaugh's, worked with Alex on numerous cases. Alex's best friend, and the state and federal government say he stole from clients. He kept part, gave part to Alex Murdaugh, stole from clients. Today, or yesterday, was his sentencing hearing, not just a hearing that was about motions or documents or discovery. It was actually his sentencing hearing. He was pleading guilty and he was sentenced. So we will cover all of that. Plus, we got some spicy new details about Murdaugh's bombshell motion for new trial. Now, we have the state's response in. I haven't had time to digest it yet. I just know what I'm reading, and you may well be reading too, that the state disagrees with them. Not a surprise after you watch the hearing from yesterday. You will not be surprised to learn that the state does not agree with the motion for new trial. If you follow me on Twitter, you already know some of the spicy new details we got about the motion for new trial. So be sure to follow me over on Lawyer Lee W, because I'm posting more regularly over there and trying to get some of the best and most important information to you over there. So now I have edited this a lot to make it more interesting and shorter. I like short. The sound is atrocious. I'm just going to have to tell you that's the way it was. Court TV had the broadcast for the world. And especially get ready to cover your ears when the judge talks. I tried turning it down for those. And I even cut out parts. It's so rough. It's just, it was really loud compared to other people. It smooths out as the time goes on, but just as a warning, this, part of it is a little bit, the audio's rough. So now, speaking of things that need help, our channel really needs your help. Please be sure to subscribe for great content about legal cases that everybody's talking about. And also, if you would hit that like button, that'll help the video get out to more people. We're covering the Murdaugh trial and motion for new trial, anything they have. And we're also covering Bryan Kohberger. We're covering all the biggest cases that you're already talking about. So one of the things I learned was that Alex Murdaugh has been indicted in multiple South Carolina counties. According to what Creighton Waters said at the hearing, he's been indicted in Orangeburg, Bamberg, Allendale, Beaufort, Carlton, Hampton, and Colleton County. I found that fascinating because South Carolina has 46 counties and he's been indicted in 7 of those. We're talking about somebody who really got around in terms of spreading all of this stuff all over the place. But we've just learned all kinds of stuff. You'll be fascinated, I think, by this hearing. So let's go ahead and get started on it.
That I've just listed against Alex Murdaugh represent 101 total charges for an alleged loss of almost $8.8 million. Your Honor, the state is here, as we have discussed, I believe, back in April, requesting a trial date for Mr. Murdaugh. I believe that we look at some of the other co-conspirators that Cory Fleming has pled was supposed to go to trial this week. But Mr. Murdaugh remains the state's priority, and I believe the case that is the priority would be the case involving the Satterfields, Your Honor. That by far represents the greatest single loss among all the victims. The state is intent and requesting the court to schedule a trial date as soon as reasonably possible, sometime before the end of this year, to try Alex Murdaugh on those particular charges.
So, as I said, you will not be surprised after this hearing to learn that the Murdaugh team disagrees with all of this. But what the state is saying is we've got a bunch of cases all over the state against lots of people, but Alex Murdaugh is the number one of the ones, certainly the ones they had today. He's saying that's the greatest single loss was the Satterfield case. Now let's talk about the Satterfield case just real quickly. Many of you will already know about it. Gloria Satterfield was the housekeeper and nanny for the Murdaugh family for many, many years. And she was found at the bottom of the stairs at Moselle, the house where they lived, with a head injury. She died a few weeks later. Never woke up, except, according to Alex Murdaugh, she did wake up, he says, just briefly, just long enough to tell him that she had tripped over the family dogs and fallen down the stairs. She was the only person she talked to. He was throughout this entire period, she did not wake up, didn't speak to anybody else, but he says she spoke to him. The reason why that was so important was that was the hook that enabled the Satterfields to sue Alex Murdaugh, his family, saying your homeowner's insurance ought to cover this because she tripped over your dogs, fell down your stairs. Otherwise, as far as I knew, she just was on the ground. Nobody saw what happened. So Alex Murdaugh told the Satterfield boys, her two boys, they were both young adults at the time, and he told them, look, count on me. I'm going to take care of this. You need to sue me. I'll take care of everything. And one of the things he did was refer them to Cory Fleming, another attorney, and his good friend. The reason, of course, Alex Murdaugh couldn't sue himself, he had to get somebody else to do that. And that's what Cory Fleming that's where he got pulled into this. We are going to see his sentencing toward the end of this, just a little brief excerpt out of it. So, and what the state says happened with Cory Fleming, and since he's pled guilty, he acknowledges this. Cory Fleming gave Alex Murdaugh a check to forge, just forge, as Creighton Waters pointed out, not Forge Consulting, just the word forge. Alex Murdaugh then took that check, which was supposedly going to go into a structured settlement for the Satterfield boys, so they would receive money over time. It was going to go to an insurance policy bought through a company called Forge Consulting. But in fact, what had happened was Alex Murdaugh set up an account at the bank called Richard Alexander Murdaugh, DBA, doing business as Forge. And so as long as the check was just written to Forge, he could deposit it. And that's what he did. And he took all the money. So Cory got the attorney's fee. Alex Murdaugh got all the rest. The Satterfields got a big fat goose egg. They got nothing. And that was one of the things that Eric Bland eloquently spoke about at the sentencing hearing for Cory Fleming. He said, you know, I've seen many cases where lawyers skimmed off some, or at least I've seen other cases where lawyers skimmed off. I've never seen one where the client ended up with nothing. And let me be clear on this, because ultimately Eric Bland did recover money for them, even more than Alex Murdaugh had originally gotten from the insurance company, but he did not do it through the actual case, but rather through lawsuits because of the fraud against the Satterfields. So the state is saying, we want to try this case this year. And you are going to hear, of course, Dick Harpootlian disagrees with that because the Murdaughs, it's the Hatfields and the McCoys, the state and the Murdaughs, they aren't going to agree. Here we go.
There are a number of different objections we have to trying any of these cases this year. We previously got the impression from Your Honor when we met at the last status conference that you would not be trying any of these cases, and you'd be leaving the bench on January 1.
Tell me about that impression again.
That was my impression based on your discussion. Now, maybe I misread you. I've done that from time to time during this process. If I did, I apologize.
So this was actually a pretty big nugget dropped in right here. Apparently, the Murdaugh team understood that Judge Newman would be leaving the bench at the end of the year. That gave them a huge reason to wait, to push the trial as late as possible, to avoid at all costs having the trial happen this year. Why? Because several things. Judge Newman has already stated he finds Alec clearly guilty. He stated, quote, all the evidence suggested he was guilty. He is a very hard sentencer, as you will find out when we talk about Cory Fleming, and has ruled against the Murdaugh team over and over at every turn. The last thing they want to do is try these cases in front of Judge Newman. They would really like to have a different judge. And if he's about to retire, if they can just push the trial to January, that would be a clear benefit to them. Now, he seemed to push back on that as if maybe that's not actually happening. Maybe they misunderstood on that.
But in the meantime, Mr. Griffin and I have scheduled other matters for this fall. Both he and I have a federal trial in December. Before that, Your Honor, and I think I mentioned this the last time we talked, I have the oldest case in Lexington County, civil case. It looks like most of October is going to be involved either getting ready for or trying that case.
And this is the pretty classic reason for delay in a case is everybody's got busy schedules and there are other cases being tried. Why does he bother to mention that it's the oldest case in the county? Because courts like to do something pretty classic. They like to take things in order if they can. If somebody's been waiting a really long time for justice, then they like to go ahead and try that case. And so that's why he mentions it. Now, I should say, typically courts put criminal cases above civil cases on the theory that these are more important to everyone than a civil case would be. There is currently in most courts around the country a pretty significant backlog following on the heels of COVID when many cases weren't tried. It was difficult to get juries to come in, difficult to conduct court, and so things got really behind. So that's not a surprise that there would be a very old case that's been waiting a long time for trial.
It wouldn't be done until early in November. And Your Honor, it's going to take some time to get ready for these cases. But more importantly, and maybe this is the toughest thing I have to say, and that is this. This case was finished 6 months ago. It clearly, I don't think anyone would dispute this, had more publicity than any case in the history of this state, and maybe the country. On national television every day for 6 weeks, the motions motions hearings were covered, and they're here again today. It has been podcasted, blogged. We've got podcasters out there who are gripping their 15 minutes, hanging by their fingernails, wanting more of their 15 minutes of fame and continue to talk about this.
Irony, 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 because there was a great meme of this moment where Griffin looks over at Dick Harpootlian as he's talking about that, and there was a little bubble over his head. He's like, wait, you mean them, not me, right? Because, of course, Jim Griffin has his own podcast, so that was pretty ironic. I agree with them that prior to trial, the publicity about the case was negative to Alex Murdaugh. Goodness knows this has been a sensational case, lots of documentaries, lots of people talking about it. But that same attention, I think, is what's going to give them their best shot at a new trial. And that's why they did the press conference on the new trial. And I want to say, too, thank you to Angela. I appreciate it.
I understand one of the solutions to massive pretrial publicity is a change of venue. There are two cases I want to cite to the court, both of them the United States Supreme Court cases. Murphy versus Florida, and the cited, I'm sorry, in Shepard versus Maxwell. There are two kinds of pretrial publicity that would indicate a continuance and or a change of venue is required. Prejudice is presumed from pretrial publicity when pretrial publicity is sufficiently prejudicial and inflammatory, and the prejudicial pretrial publicity saturates the community where the trials are held. They found presumed pretrial publicity in a case much less renowned, much less publicized than this one. And Your Honor, to try this case in less than a year after the verdict came in the other case, don't we need to let it calm down a little bit? Where are you going to get a jury? Mars? I mean, there's nowhere in this state.
Allendale, Orangeburg, Beaufort, Colleton,
Your Honor, and I
Hampton.
appreciate your sense of humor.
This sense of humor, we have many counties where these indictments were issued.
So Harpootlian is saying, and I know it can be difficult to hear that, Dick Harpootlian, Alex Murdaugh's attorney, is saying, look, we don't want to try this in Colleton County. We need a change of venue because there's been massive pretrial publicity. And his point is, where are you going to go? He makes the joke, where are you going to go to get a jury? Mars, because everybody's heard about their case. There's nobody just about who hasn't heard at least a little bit about it. Certainly true in the state of South Carolina. And the judge says, well, we've got other counties. And Dick Harpootlian says, that's not going to help. And I will say this, I went ahead and looked it up because I was curious about this. If you just look at this channel, this one channel, we have people from all 50 states who have listened to this channel. 27% of the people listening aren't even from the United States. And they come from 48 different countries. So what that says to me is there is a lot of interest and attention on this case. A lot of people are interested in it. It's not limited to South Carolina, and it's certainly not limited to Colleton County, South Carolina. It spreads without question throughout South Carolina. So what Dick Harpootlian is saying is, let's not just look at a change of venue as in pick up the trial and move it from Colleton County to one county over. Let's talk about doing something like giving it time. Let people forget about it. Let the excitement and the drama die down. Then we can talk about it.
I'm not presuming any prejudice, and the test is not based on speculation. The test is whether or not a jury can be impaneled. You first have to attempt to get a jury according to the law.
What I'm saying is, I think it's...
I have to say, I was a little surprised by this because classically what happens is the judge makes a decision about whether a fair trial can be held in a particular location, and if not, then makes a decision in advance about moving it. The judge seems to be suggesting that that's not the way it works in South Carolina, which could be the case. I don't practice in South Carolina. And so the judge is kind of implying what we're going to do is bring a jury in and see. Maybe we can get a jury. And remember, the touchstone is not whether or not the jury has ever heard about the case. It isn't, have you ever heard about the case? Do you think it's, have you formed an opinion about the issues about to be tried here? Have you formed an opinion and you don't have an open mind? Are you unwilling to consider both sides as we argue the case? And that is something that the judge is saying, I'm going to wait until I actually talk to the jury. We're going to bring them in and then I'll make my decision if we truly can't get a full jury. That's a lot of work. And it's a lot of expense, though, to go through all of that to determine a jury. So I thought of, for example, the Lori Vallow Daybell case, where the judge made the decision in advance to move the case across the state or a ways across the state so that it would be more likely they could get a jury that wasn't as involved, didn't know the players, and didn't know the case. Oh, and we are about to get to the spot. Get ready for the juicy tidbit about the motion for new trial that we've been talking about on the channel.
Be an exercise of futility. I know this. We've been interviewing jurors, as you know, in the murder trial. There was a juror who on that jury who could have been excused, been on the jury panel within the previous year, and told other jurors, "I want on this trial. I want on this trial." And that, I'm afraid, is what happened on that jury. We've got
Super interesting. That's really important information for a couple of different reasons. The motion for new trial that was attached to their motion asking to put the appeal on hold, on stay, that motion that they attached as an exhibit had affidavits attached to it. There were 2 straight from jurors and 2 about jurors that the Murdaugh team had talked to. Since there were a baker's dozen jurors, because there were 12, of course, who served on the jury, and 1 was actually kicked off the jury the morning of deliberations. So the new jurors were, what this says to me, that fact right there, that there was a juror who said, "I want on this trial, I want on this trial," that was not in the motion for new trial. So that suggests to me that the Murdaugh team is now talking to more jurors, that there are some who have agreed to talk to them now and weren't talking to them before, something more than the 4 affidavits, 2 from jurors and 2 from the paralegal who interviewed them, but not actually signed by the jurors. We covered that in other videos. I'll link at the end. But this fact is new. The idea that one juror said, I want on this trial is new. And the second thing that's important about that is that not only have they gotten more information than they had gotten before, and does it suggest that more jurors have begun to talk to them, but also it suggests that this particular juror may not, we don't really know, have answered falsely on questions because they were asked about their knowledge of the case. And who knows, I imagine that the Murdaugh team wants to grill that juror about what they'd heard about the case. Why did they want to be on the case? What publicity had they seen? What podcasts were they watching? And is that the same answer that they gave during voir dire? We don't know. A lot of that was private, so we can't really answer that question. But what I can see brewing is an argument from the defense that this juror maybe didn't answer properly. I can't say with the facts. We don't have enough. We just know that there's a little tidbit that there's some more information coming out from the jury than there was before.
Motion for a new trial for after discovered evidence. The court, the Attorney General is going to file their response tomorrow. We believe the Court of Appeals will order a jury before a circuit court judge to determine whether or not the clerk of court tampered with that jury. And that is and so we would go forward with another trial while that matter is pending, while that matter is being litigated?
Probably not in Colleton County.
Okay, another really significant point in the hearing right there. First of all, let's back up a little bit. The motion for new trial that I mentioned, what the Murdaugh team is saying is that they believe the clerk of court, Becky Hill, was interfering, tampering with the jury, and that she influenced them or at least was talking to them about the facts related to the case. That's what their motion for new trial is about. And they say some jurors will say that. They attach affidavits from 2 jurors talking about these topics. And then they attach the affidavit from the paralegal saying, I also talked to these other 2 jurors who said the same thing, even though I don't have an affidavit from those 2 jurors. When the judge says, Dick Harpootlian says, we've got this motion for new trial pending, and do you really think that while that's being heard over in Colleton County, we're going to go on with trial on these financial crimes while this hearing is pending? And the judge says, probably not in Colleton County. That answer suggested to me that the judge has at least contemplated the idea of a hearing, already thought about this, wasn't a total shock. And so I thought that was really interesting.
Well, Your Honor, the idea that somehow something happens in Colleton County doesn't affect what happens in Beaufort County. I mean, this is a national case. I mean, do they not have television in Allendale County?
I don't
Do they
know.
not have the internet?
I don't know.
So what's the hurry? That's the other point. What?
So Dick Harpootlian's making a couple of points here, and I want to say thank you to Snoop Catty Cat. Thank you very much. What he's saying is that first of all, that they can't just move county to county and expect other people to not know about it. That it actually is something that is moving one county is not going to accomplish anything because everybody has the internet. Everybody has heard about this. The world has grown significantly smaller. And it is true that the internet is dramatically changing the way that lawyers interact and the way that juries know about cases in advance. But the second thing he's saying is, what is the hurry? Why are we in a rush? He's in jail for life. He's admitted the crimes of the financial crimes. Why do we have to try this now? I mean, he's going to be sentenced in federal court. He's going to be sentenced here. I mean, is there really a rush? So that's what he's arguing.
Is the hurry? He's pleading in federal court next Thursday. Every allegation the state has made, the victims will have their day in court. We plead, Mr. Murdaugh indicated he pleads guilty to state charges, but the state insists on doing them in serial so they get 3 convictions so they get life without parole on a guy who's already serving 2 life sentences without parole.
So this is important. Dick Harpootlian is saying that Alex Murdaugh would be willing to plead guilty, or at least I hear it this way. He'd be willing to plead guilty to the state charges on these financial crimes. But the state is choosing to break them into pieces because it wasn't, it wants 3 convictions. If it gets 3 convictions, and under the law, apparently, Alex Murdaugh would get life without parole. And that's what the state is aiming for by breaking them down and by seeking 3 convictions. So I don't know the details of how it works in South Carolina, but that's what Dick Harpootlian is saying. And thank you, Pamela. I appreciate it.
This is just another attempt to get more publicity, to make this another national case. And, Your Honor, I'm offended that the Attorney General he's got many other cases that are much older than this, but granted, court TV won't be there for them.
So let him say one more.
Another effort at creating a national spectacle. Now,
this shows just how testy the relationship has become between the attorneys, just how much they don't get along. And actually, I think this suggestion by Dick Harpootlian, that's really not fair. And he's about to get his hat handed to him from Creighton Waters. So you're going to hear that in just a minute.
Your Honor has some things to say about Mr. Murdaugh to sentence him. You obviously believe he was guilty of that. You obviously, and the jury found him guilty of that. But I would ask you to put those feelings aside and give us a chance to litigate this jury tampering issue.
In the last video, we talked about what the clerk, Becky Hill, said in her book, the one that the Murdaugh team says broke open the jurors' willingness to talk to them. This is the book written by the person they say tampered with the jury. We talked about the perception of fairness issue. And one of the things that the Murdaugh team is dancing around is the fact that the judge has said he believes Alex Murdaugh is guilty and that all evidence pointed to that. He also did a televised interview. They have not yet argued that it would be impossible to get a fair new trial with this judge. They haven't argued that. In fact, they kind of stepped back from that when they were doing their press conference. But one of the issues that they may raise at some point is whether there is an appearance that the judge can't be fair on a new trial. We haven't reached that point yet. I'm just telling you that he's throwing this out there. You've already said, Judge, that you believe he's guilty. They said the same thing at the press conference. Thank you, Jennifer. I appreciate it.
To allow Mr. Griffin and I to have time, if there is going to be a trial on these, prepare for the trial, which we won't with our calendar for the fall. And third thing is, why doesn't the Attorney General put some distance between the conviction in the murder case and the trial, if there has to be a trial, on the financial cases? I'm, as you know, as a prosecutor, I'm bewildered by this. Certainly they can do it, but why? Why? What is the hurry? Thank you, of course, no. Thank you, Your Honor.
And he does have a point here. There really isn't a need for a rush. There isn't a need for them to rush over and make sure that Alex Murdaugh is convicted here, because in fact, he isn't going anywhere in the near future. They do have a point on that. But now Creighton Waters is going to answer very clearly that allegation that this was all for publicity.
Your Honor, this isn't about a spectacle. These white-collar indictments have been investigated by the state grand jury, which is a partnership of the AG and SLED. This is about allegations that represent an assault on the state judiciary. And because of that, they need to be answered. The law is very clear, is that you don't presume prejudice, you try to seat a jury, and through that process can the court then assess whether or not a jury can be
Here, we previously got the impression from your...
Let me stop it right there. So Creighton Waters is saying, look, this isn't just about publicity. A grand jury found reason to try him for this. That he has created a black eye on the entire judicial system in South Carolina. This is very serious. This is not about grandstanding. This isn't about court TV or broadcast or podcast. And he also argues we don't really have to get into the whole issue of change of venue yet. Let's just see if we can get a jury that has not yet prejudged and already made a decision about him.
Your Honor, when we met at the last status conference, that you would not be trying any of these cases, and you'd be leaving the bench on January 1.
Tell me about that question again.
I hate it when I do that.
the state capacity. That just leaves nothing left to happen. This is just the reality that we live in, and so we depend on the...
Not sure exactly where I was.
Thank you, Course.
Oh wait, we were right about there, and then we were a little further along with Creighton Waters.
That represent an assault on the state judiciary. And
give me just a minute, we'll catch up.
They need to be answered. The law is very clear, is that you don't presume prejudice, you try to seat a jury, and only through that process can the court then assess whether or not a jury can be seated. We are in 2023. The reality of the media environment is what it is. And unless we're going to say the judicial system just can't function because of publicity, that just leaves nothing left to happen. This is just the reality that we live in. And so we depend on the ability of the system, we depend on the ability of the jury selection process to seat jurors. And that is what should happen. And only if there is an inability to do so can this court then consider whether or not there needs to be some change of venue or some relief or something like that. That is exactly what the process should be. And this is a big county, this is Beaufort County, and fundamentally, just as we...
I must say, I don't think, given the scope of this, that Beaufort County as a big county is enough to be able to get away from the publicity. I think Dick Harpootlian had a good point that time might be better than moving it. But what Creighton Waters is arguing is we just go through our normal process. Yeah, there's more publicity, but we may be able to get a fair jury. And only if we can't get a fair jury, only then do we actually worry about whether or not we need to move. We don't just go worrying about that now. We don't just change. So that's not the law everywhere, but that's what he's saying the South Carolina law is.
We rely on lawyers, just as we rely on judges. to be objective about what they do, and that includes the defense motion here. Okay, we have an objective duty. We also the system depends on jurors to be objective as well. And to just say, because there's publicity, nothing can be done, just throws the system out and leaves no recourse whatsoever. And what the defense can't do is try to essentially run down the street to the federal authorities and bypass the accountability that needs to happen in state court for a direct assault through use of a state law license on this courtroom, Your Honor, on the other courtrooms or the other counties that I named. The state judiciary.
So the state is saying, look, the question is not whether, the question is whether we can find a jury that can make an unbiased decision. It's not whether anybody has ever heard of the case, because they may well have heard of the case, but that's not how we decide whether or not they can sit on the jury. This is something that all of us have to participate in. He's saying the judge has to be like that. The prosecutor has to be like that. The jury has to make the decision about whether they can be unbiased, and the court does as well. And so that's what we're looking for, not whether anybody's ever heard of it.
The state judicial system needs to answer for the allegations of this assault.
So I think he has a very profound argument there, Creighton Waters does, because what he's saying is this is an assault on the entire judicial system of South Carolina because of the way they acted. And the state judicial system as a whole needs to address it for that very reason. I think that's a profound argument.
You know, of where we're at today. In addition to that, I would state for the record, I want this clear, based on that is Mr. Griffin and my trial schedules in other cases between now and the end of the year, we would be ineffective in preparing for this trial, any trial.
Your Honor, that is absolutely not what happened.
Then let me stop for just a minute and explain. When Dick Harpootlian says we would be ineffective if we have to go this fast, given our schedules, ineffective assistance of counsel is the touchstone that everybody is worrying about, because that's what's going to be considered on appeal. Has the counsel been ineffective and therefore not been able to safeguard the rights of the defendant? And so Dick Harpootlian is raising that specter, that idea, oh, we might be ineffective because you pushed us too fast and we couldn't realistically do that. And of course, it will not surprise you to know that the state disagrees.
I even said I was happy to try the white-collar cases first. It was the defense's motion for a speedy trial and Mr. Harpootlian's waiver of his legislative immunity, which is what led to the murder cases being done before. It was the defense that wanted to trial the murder case. They filed a motion for speedy trial, and the state said, okay, let's do it.
He had a decision to agree with that, Your Honor. It was up to him. He's calling the case today. The solicitor calls the case, the prosecutor. We don't call the case. It was his decision. He decided to go with the murder case first.
Your Honor.
It's going to get even testier. Keep watching. They are really, anyway, you keep watching.
The state is happy to show up in court and seek justice for these very important matters whenever a date can be scheduled. And the only reason the murder went first was because of Mr. Harpootlian. Significant pretrial issues, it might even make sense to have a hearing prior to the trial date so that. So,
okay, the judge has said at this point that the judge is about to say he rules at this stage, and I'll just go ahead and I'm going to shortcut this. The judge said, we're having this trial before the end of the year. We're not waiting until next year. We're not going to let you run the clock. We're having the trial, and he set it for November 27th in Beaufort County. So they then discussed setting a deadline for the motions that need to be filed in advance. This is really small. This is not something that there would normally be any drama over at all. This would normally be very minor, and yet it's so tense between the parties that even this turned into something dramatic.
If there's resolution of those, we can hit the ground running with that trial week.
Your Honor, none of this is a big concern. I don't know why we just can't deal with it that morning. I mean, our schedules really are complicated. Can't we have the hearing that morning?
The morning of the trial?
Yes, ma'am. Yes, sir.
Well, a deadline for filing the motions.
I don't have a problem with that. 10 days prior to trial, and responses 5 days before trial.
Okay. I think, in effect, that's what you proposed.
Yeah, Your Honor, and I apologize, the 10th is Veterans Day. We could have the motions filed on the 17th.
My God knows I don't want to have to work on Veterans Day. Oh, my God.
I just pointed that out, Your Honor.
I know the state government people enjoy these holidays, but we're going to have to rearrange a major personal items to deal with this. I plan to take Thanksgiving and visit my wife overseas. That ain't happening now. I've got to call when I leave here to tell her. So, perhaps we'll have to work Veterans Day, I'm sorry. I suggest that's not a
I
bad.
would say these people next to me work just as hard as they do, and Your Honor saw that.
We'll be working Veterans Day, so why don't you match it?
So you can see how incredibly tense. Dick Harpootlian is sort of making a dig. He's suggesting, these are a bunch of slackers, government employee slackers. And, you don't work Veterans Day normally. We work hard. We work Veterans Day. Like, that's not even something we should be thinking about. Of course you would work on Veterans Day. You would just work that. You're an attorney. It's your job. And you, the government, are kind of slacking off. So they just got into that kind of fight. So I will say that one of the things I do now is I'm a mediator. So I help people resolve their cases before they have to go to trial. And this is a really common phenomenon because lawyers, as part of their job, oppose each other. Somebody files a motion and I file a motion against them. They want to do something, I oppose that. That's just how the legal system is set up. And so lawyers get into, over time, they often sort of get into the animosity of it. They get into the me versus you, the argument side of it. And it can be really hard to settle a case. And so I talk to them about, you've got to set that aside. For today, we want to see if we can agree on the case. So you can't, everything they say you can't oppose, but that's obviously happened over time as the case has been pretty bitter. So the judge at this point very calmly set some deadlines, said, and they are now going to be handling all of those before the trial gets started. This was a small deal and he handled it very appropriately. So what I want to talk about now is Russell Laffitte. That was part 2 of the hearing. That was part 1, Alex Murdaugh. Part 2 was Russell Laffitte. That's the banker. And his allegations against him, for example, are that he was a personal representative for several of Alex's clients and was actually paid $400,000 to be the personal representative, but he loaned himself money out of their accounts. He loaned Alex Murdaugh money out of their accounts. And then when Alex couldn't pay it back, he knew, the allegation is, that Murdaugh was taking the money from one client to pay back another client, and that it was just sort of circling around, and eventually somebody was going to be left holding the bag. He even, according to the federal allegations, loaned money from his bank. He was in charge of the bank, and he loaned money from his bank to Alex to start covering some of that. He was convicted in federal court, has been sentenced to 84 months or 7 years. He's due to report September 21st, unless the Fourth Circuit, the Federal Court of Appeals, grants him an appeal bond. So they put all of that off, which was interesting in light of the fact that nobody would move Alex Murdaugh's case, but Russell Laffitte's case got moved to sometime next year, and nobody seemed to be in much of a hurry about it. And then I want to talk about part 3. Cory Fleming, the attorney, the close friend of Alex Murdaugh's, he pled guilty. So this was actually his sentencing. He showed up in the garb. He's has pled guilty already in federal court, where he received 46 months, just about 4 years. And now he was coming in for the state charges. And I'm going to talk about that in just a minute. But for the allegations against him were not just, as in federal court, what he did related to the Satterfields. There was also a second case. It was not covered in federal court because of the statute of limitations, but that was covered in the state case. And that was the Pinckneys, that he had represented the Pinckneys, again, at Alex Murdaugh's request. And the Pinckneys, he spent time with the family and got to know them. They had been injured in a car wreck, and he stole money, according to these allegations and according to his own admission, from the Pinckneys. One of the things they mentioned that he did was there was a pot for medical expenses for the Pinckneys, for specifically his client. And the medical expenses were used to pay for a private plane to take Alec and Cory to the college baseball World Series, and that they used this fund as if it were their own fund, and it was her money to cover those medical expenses. So he pled guilty just to Satterfield in federal court, and here he was in state court on both counts. So Creighton Waters did a really eloquent, more or less like a closing argument, because this was sentencing, and he talked to a couple of things he said were that he shouldn't get, Cory Fleming should not get one-stop shopping for victimizing multiple people. He shouldn't get buy one, get one free. Like, you were sentenced over here for Satterfield, well, the Pinckneys are free. That you don't, and he also said you don't get to rob a bank, then run down the road and get caught and say, oh, here's some money, we're cool now, right? And he said you can't do that. So Cory's team was asking for a concurrent 46-month sentence. In other words, they wanted the state court to say, look, you've already got 46 months, you get 46 months here, you can run them together and you'll be out in, with good behavior, 85% of your almost 4 years. So I have edited this a lot, edited it way down, but I wanted to give you this because it's what he said at sentencing. This is his statement. And I wanted you to contrast this with what Lori Vallow Daybell said, if you'll remember that. It was so tone deaf. It was so wrong and inappropriate for what it was. But this is, I thought, so well done. And also, I thought you might be interested to compare it to what Alex Murdaugh said at his sentencing. That was a little different because Alex doesn't admit that he killed his wife and son. So obviously you wouldn't expect him to be contrite if he continues to maintain that he didn't kill them. So let's go ahead and listen to what Cory Fleming said.
For many years I stood in this very courtroom representing people. Many of those people had broken the law. Today I offer this court no excuses. There are no excuses. I place the blame for my actions on my shoulders, nobody else's. I never imagined standing here and being in this circumstance. I have a profound and deep disappointment in myself.
One of the things he's done right there so far is take responsibility on himself. He hasn't found 50 other people to blame. He said, I'm disappointed in myself. And many judges want and appreciate that.
I don't think I can say how sorry I am too much to any of these people. So I'll say these words again to the Satterfield family. Your mother was a very good woman. In the aftermath of losing her so tragically, suddenly, you deserved a lawyer that had only your best interest at heart. You deserve someone to be honest with you. You deserve someone who talked with you. You deserve someone who dealt with you fairly. And you deserve someone who would not betray your trust. I did not do those things. I failed you. To Michelle Pinckney, I not only betrayed you as a client, I betrayed you as a friend. You suffered a tremendous loss that no parent should ever endure. You and your entire family were good to me. I have no words for how empty I feel when I think of how you must feel about me. You deserved much better. I failed you and I failed your family. To both the Satterfields and the Pinckneys, for these failures, I am immensely sorry. I know that an apology is inadequate, but please know that I am genuinely incredibly sorry for my treatment of you. My actions have cast a negative perception on the legal profession. I understand that the public's confidence in our judicial system has eroded as a result of this case. I have permanently resigned from the South Carolina Bar because I no longer deserve the privilege of practicing amongst you. A lot of people have spoken to me, my friends in the community, about what I've lost in this ordeal, but I'm looking at all that I've gained. I've had to take a very hard look in the mirror. I didn't like everything that I saw. I've grown from this both spiritually and emotionally. I've taken stock in my life and realized how lucky I am. I'm incredibly grateful for my wife, my children, my family, and my friends for their support and love. I believe there were times in my life when I took these people for granted.
So, in my view, and I saw somebody asking what's your view, I thought that was really well done. I thought it was very believable. He just in terms of his tone as well as in terms of what he said. And when you contrast it with Lori Vallow Daybell, or even with the way that Alex Murdaugh talked about the financial crimes during the trial, it's just really, really different. He seemed broken to me, and it did him no good whatsoever. So the judge talked about, I'll give you a little explanation of what he's about to talk about. There was a case involving a mother of a disabled child. She had cared for the child for many, many years, and then she left the child in the car seat for a period of time, hours, and it was very hot, and the child died. And during this, it wasn't just that she left the child alone and just forgot, something like that. It was that she apparently used meth, and she and her boyfriend did other things. They used meth, and that's when the child was left in the hot car. So, and the judge is going to refer to that case, which was also broadcast on, I guess it was Court TV. He said it was just 2 weeks ago.
And you're talking about remorse, and the testimonies and presentations over this mother and her mistake. She was on methamphetamine with her boyfriend. As remorseful, I cannot imagine anyone giving me a presentation of a mother who loved her child and who went wayward and more concerned about using drugs and pleasing her boyfriend than caring for her child. And she got 37 years in prison, convicted of murder. That was 2 weeks ago, here in the same 14th Circuit. And the folks who came to talk with him and said, you know, she loved her child. Nothing she wouldn't do for her child.
So you can kind of tell from this that Cory Fleming's team has to be already guessing that things are not about to go well for Cory Fleming, because you can tell from this 37 years was an extraordinarily high sentence under the circumstances. And this judge gave that sentence, and he's already referring to that case. So we'll keep going.
Yeah. And so he placed his trust in a respected member of the bar, a very respected member of this community. We all have good and we all have bad, and certainly everyone was here to tell me about all the good in Mr. Fleming, but we're dealing with the consequences of the bad, and that is as bad as it gets in this case for a lawyer. And quite frankly, when the people come to me and wanted to lay the burden on me, said, Judge, please be lenient, that's not my responsibility. You know, I believe in justice and mercy, but leniency is not part of Micah, the scripture. Facing 195 years in prison.
My heart bleeds for you because I have no doubt of the quality of human being that you are, as reflected by all of the positive comments. But you must suffer the consequences of your actions.
So what, and I'm going to leave that up because there's something more I want y'all to see. We're going to flip back to Alex Murdaugh in just a minute. But so there followed from there sort of a real confusing discussion about all the numbers for this count and that count. But the bottom line was that he got 20 years, of which 4 would be run concurrently with that federal sentence, or about 4. So the state has apparently an 85% rule on felonies like this, that you must serve 85%. But there are some exceptions to that. Drew Tripp from WCIV TV in Charleston concluded from all that it would probably be about 14 years, but the South Carolina Department of Corrections was going to speak to that. So he's 54 right now. So if 14 years is correct, the earliest he would get out would be at age 68. So I want to answer a couple of questions really quickly. Why are there federal charges and state charges for the same thing? That is the rule, that you can be charged federally and state because they're separate sovereigns, they're separate governments, and they have their own laws. I personally don't really think that's fair, but no one asked me. And so that is what the law is. Federal and state, you can be charged for both. To me, it's kind of like you get a ticket. You're parked outside the federal courthouse, and the state comes along and says, oh, here's a ticket, you double parked. Like, oh, dang, there's $100. And then all of a sudden along comes a federal employee and says, here's another ticket because you parked in front of the federal courthouse. And so, you know, that's the way it is. Obviously, this is way more serious than that. This is nothing like a parking ticket. I'm just saying it seems like double counting to me. But that is the rule. And then someone else asked me, I didn't ask permission to give her name, but she asked me about why would there be 4 years in the federal court and then 20 in the state? One answer would be that the federal didn't include the Pinckney case, and so there was an additional case. But still, why 20 years instead of 8? Why that huge difference? Well, that is something that depends very much on the judge, and this judge gives heavier sentences than obviously the federal judge did in that other case. And so that's just the explanation for it, that it's just different. It just depends on the court and the case and the judge and what the charges are. And in this particular case, they're really different. 20 years and 4 are just really different. And actually it was a little under, I believe it's 46 months is what he got there. So I want to end with the strangest moment of the day. The strangest moment of the day was Alex Murdaugh being led out of the courtroom on a leash. I don't know that you could say it any other way. Take a look. So I guess that's a thing. I've never seen that before, but I certainly thought it was interesting and I thought you would want to know about it. We have so much to cover. It's kind of hard to narrow it all down. I definitely want to cover the Delphi case starting next week. I'm going to compare it to the Koberger case. We'll be doing an update in that. We've got the Lori Vallow Daybell appeal about to drop. The state has responded to Alex Murdaugh's bombshell motion for the stay and motion attached, the motion for new trial that's attached to it. And we're going to be covering all of that as fast as we can possibly get to it. So be sure to hit the subscribe button. We'd love to have you back for more. Hit the like button if you would for the video as you're going out. It'll help the video get out to more people. And I will see you. We go live Monday, Wednesday, Friday at 7 p.m. So I'll see you Monday at 7 p.m.